23 CR 103, State of Ohio versus James Duffield. Appearing on behalf of the state is Assistant Prosecuting Attorney King. Mr. Duffield's counsel of record is Jeffrey Meadows. Who are you?
Good afternoon, Judge. Lisa Wells. I work for Jeff Meadows, and we electronically entered my appearance earlier, about a couple hours ago.
When was that?
Today, about 12 o'clock.
All right. Well, I haven't gotten that, so, all right. All right. So Mr. Duffield is charged with pandering obscenity involving a minor, a 4-3 felony. This is a first pretrial. Final pretrial set for next, on the 23rd, and the trial date is September the 25th. I see the state's provided discovery on July the 27th, and don't see any compliance by the defense yet. So your discovery is due by the final pretrial, as well as by local rule. And are you anticipating any pretrial motions?
Possibly. I mean, there's possibly a motion to suppress, and then I had some questions for the prosecutor about some discovery that was provided. So yes, it is a possibility.
All right. Well, that's also due by the final pretrial under local rule. All right. Has there been a written plea offer provided?
Yes, there has, Your Honor.
All right. And is Mr. Duffield aware of that?
Mr. Duffield is aware of the offer that's been made.
All right. All right. Are they the matters then to discuss at this time?
Nothing from the state, Your Honor.
Only that in discovery, the prosecution provided the image to me that is alleged child pornography, which I'm not comfortable having, maintaining, or keeping, so I'd like to give it back to the state. I've never actually been provided child pornography in an obscenity case.
Well, it's between you and the state. It's not, it's not my problem. So
Part
you do whatever you want to do.
Part of the discovery.
Yeah. I mean, if you don't want it, that's up to you.
I didn't believe legally I could possess it.
Well, that's up to you. I'm
Okay.
not making any comment on that one way or the other.
And then, Your Honor, is there an expert deadline from the state?
Well, under Rule 16, yes.
Okay. And
16K. Yeah, they have to give you a report in the ZV within 21 days prior to trial.
okay, thank you, Your Honor.
All right. Anything further?
No, Your Honor.
All right. Thank you.
I'm not ready because we have court.
Okay, this is case number 23 CR 100, State of Ohio versus Hallie Loretta Joe Pollard. Your Hallie Loretta Joe Pollard appearing there on the screen marked PCRC.
Yes, sir.
All right. Ms. Pollard's attorney is Danielle Witt. She is appearing from her office. This hearing is being conducted by Zoom. Appearing from the prosecutor's office, Assistant Prosecutor King. The defendant is charged with illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility and aggravated possession of a fentanyl-related compound. This is a final pretrial, and the trial is set for August the 31st. Now, Ms. Pollard, I have received the proposed plea of guilty form, which is a 3-page document, and I'll first of all put up to the screen the first page. It has your name, plea of guilty, case number, and the charge that you're proposed to plead guilty to. And do you see that there on the screen?
Yes.
And you recognize that?
Yes.
All right, this is a 3-page document, and on page 3, there's a sentence not quite halfway down the page. It reads, "I enter this plea voluntarily." And below that appears to be signature Hallie Pollard, and I'll hold that up to the camera as well. And is that your signature there on that page?
Yes, sir.
When, or at least it's a copy of it, correct?
Yeah.
All right, and when did you sign that document, Ms. Pollard?
This morning.
All right, and when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And had you discussed this with your attorney before you got the plea form?
Yes.
And did you have an opportunity to read it over and make sure you understood everything?
Yes.
And did you ask her to explain it to you and answer any questions before you signed it?
Yes.
And did you sign this document and agreement to plead guilty voluntarily?
Yes.
All right, now the agreement states you're going to plead guilty to count 1. The indictment, illegal conveyance of drugs of abuse into a specified detention facility in violation of section 2921.36A2 of the Ohio Revised Code, a 3rd-degree felony. Further states that you understand that the possible prison term for that is between 9 and 36 months, and there's a possible fine of up to $10,000. You understand that?
Yes.
And are you currently facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony? Not the supervision in this case, but any other case?
Oh, no.
Okay. Now, under the law, if you should be convicted and if you should be sentenced to prison, upon completion of that prison term, the law provides that the Adult Parole Authority may, at their option, put you under post-release control, which means that you'll be supervised by a parole officer on the terms that they set, and that could be for up to 2 years. If during that period of time they determine that you have failed to comply with that, then they could return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if your violation is a new felony, then in addition, whatever sentence a judge in the new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively the sentence in the new case. You understand that?
Yes, sir.
Right now, under the Constitution, I'm getting ahead of myself. Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, meaning that instead of going to prison, you'd be put under the supervision of a probation officer under terms set by the court for a period of up to 5 years. During that period of time, probation department felt that you were not compliant. They would file a written notice of that with the court. There would be a copy given to you. There would be a hearing. You would be entitled to have an attorney to represent you. The outcome of that hearing was that you'd failed to comply, and at that time, the court could revoke your community control and then sentence you to prison for 36 months, fine you $10,000. Do you understand that?
Yes, sir.
Right now, the charge alleges in count 1 that on or about October 21, 2022 in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, the Highland County Sheriff's Office, and there's some other language there that's totally inapplicable, a drug of abuse as defined in ORC 3719.011, to wit, a fentanyl-related compound in violation of section 2921.36A2. So that's the charge. Now, do you understand what it is the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
And have you discussed the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of alcohol or drugs at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there are two lines and a little more, 2 and a third lines, I'll say, printed in bold and underlined, which read as follows. Defendant shall enter a plea of guilty. State will dismiss count 2. Guilty to count 1 is what it should say. I'm going to add that. It says plea of guilty, but it means 2 count 1 was left out. So, counsel, you don't have an objection to me putting that in there, do you?
No, Your Honor.
All right.
No, Your Honor.
State will dismiss count 2. State and defense jointly recommend community control and substance abuse treatment. Defendant will cooperate fully with the state. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, Ms. Pollard, the matter sentences up to the court, not to the parties. And so even though there's an agreement between you and the prosecutor that you should get community control or probation, the court's not bound by that. So if you plead guilty, once all the information has been submitted, if I determine that that's not the correct sentence, you could be sentenced to a term of incarceration between 9 and 36 months and fined $10,000. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. Your first one is that you have a right to have an attorney, and you were appointed an attorney by the court since you didn't have the funds to hire one, Ms. Witt. Her appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide you don't want to do this plea here today, that you want to defend against this charge, she will continue to be your attorney, represent you, and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Right now, in the Constitution, Ms. Pollard, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county, summons for jury duty on your trial date. After the 12 folks are selected, the evidence will be presented, they'd be instructed on the law. And then that jury of 12 people would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive, which means to give up in writing your right to have a jury trial. In that case, it would be a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Dan, contact the jail and tell them to bring Mr. Ison in, because Denny's on the screen. Tell them we'll get to him in just about, it'll be about 5 minutes. All right, now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in public in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, the attorney that you have would ask questions. That's called cross-examination, the purpose of which is to try to bring out evidence that might help your side of the case. Do you understand that?
Okay.
Do you understand that?
Yes, sir.
All right. Now, under the Constitution, Ms. Pollard, you have a right to use the power of this court to compel or force witnesses to come to court to testify on your behalf, the same as in the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come into court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
All right, now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof is upon the state to prove your guilt. The burden of proof isn't on you to prove your innocence just because you've been accused. In fact, under the law, you don't have to present any evidence at all. You can, but you're not required to. But the burden of proof will be upon the state to prove your guilt of that charge by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right. Now, originally you entered a plea of not guilty to the charge. The not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I just described. And if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, and admits that you're the one who committed that crime. And that plea waives and gives up all of the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. It waives, gives up your right to confront witnesses against you and to cross-examine through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under the limited circumstances, an appeal could be filed, it have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen? Are you a U.S. citizen?
Yes, sir.
All right. Do you have any questions, Ms. Pollard, about the charge, the possible penalties?
No, I do not.
You understand them?
I do.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You understand the recommendation on sentencing is not binding on the judge?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea?
No, sir.
You understand?
Yes.
Do you need to talk to your attorney about anything before we go any further?
No.
You have any questions about anything I've explained to you?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to count one of the indictment pursuant to the terms of the agreement that the court has just given you?
Yes, sir.
All right. Then as to the first count of the indictment, it alleges that on or about October 21, 2022 in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, the Highland County Sheriff's Office, a drug of abuse as defined in ORC 3719.011, to wit, a fentanyl-related compound, in violation of Section 2921.36A2 of the Higher Revised Code, the charge of illegal conveyance of drugs of abuse onto the grounds of a specified governmental facility, in violation of Section 2921.36A2 of the Higher Revised Code, a third-degree felony, carrying a possible prison term of between 9 and 36 months, in increments provided by law, and a fine of $10,000. How do you plead?
Guilty.
All right. Court finds on this day in open court, defendant was advised as well as her constitutional rights made a no intelligent voluntary waiver of the same. Pursuant to Criminal 11, please accept an order filed. Defendant's found guilty of the charge as set forth in count 1. Count 2 is dismissed. The court will order a pre-sentence investigation be done by the probation department under the same, with the assessment for continuation of substance use and or mental health issues included. Bond will be continued and sentencing will be set for September 27th at 9 a.m. All right, anything further from counsel?
No, Your Honor.
No, Your Honor. All right. All right, I want to do Mr. Amberger real quick. He's been there. He was scheduled earlier. Okay, 23 CR 119, State of Ohio versus Joseph Eugene Amberger. And you're Joseph Eugene Amberger, appearing on the screen, Mark Scott Ward.
Yes.
All right, this hearing is being conducted by Zoom. Mr. Amberger's attorney is Danielle Witt, appearing from her office, appearing on behalf of the state Assistant Prosecutor King. Bench charged in a single count indictment with receiving stolen property, 4th-degree felony. This is a first pretrial, I believe. Final pretrial set for September 6th. We have a trial date of September 25. I see that discovery was provided, and Ms. Witt, your discovery will be due by final pretrial. Do you anticipate any pretrial motions?
No, none at this time.
And has there been a written plea offer received?
There has.
Is your client aware of it?
No, he's not. I need a phone number for him.
Yeah. Okay. What facility are you in, Mr. Amberger?
TCC,
Okay.
the Counseling Center,
All right. Have you a phone number there you can give her to get in touch with you?
740. Yeah, I'll give you my cell phone. Give me 1 second there. Shoot. It'd be 740-370-2649. That's my cell phone.
Okay. All right, I'll give you a call.
All right. And you can give her a call as well, too. All right.
Okay.
Anything further, counsel?
Yes, Your Honor.
All right. Thank you. All right. State versus Joey. Unmute, I should say. All right, case number 23CR102, State of Ohio versus Joey Allen Eisen. You're Joey Allen Eisen, appearing there from the jail.
Yes, sir.
All right, Mr. Allen's, this hearing is being conducted by Zoom. Mr. Allen's attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. The defendant is charged with aggravated possession of methamphetamine, a 3rd-degree felony. Now, the court has been provided with a proposed plea of guilty form. Should say that Mr. Eisen's trial date is set for August 31st. Now, Mr. Eisen, I have been given this plea form, and it says on the first page the name and case number and the charge that you're proposed to plead guilty to. I'm holding that up to my camera on my computer, and can you see the first page of that with your name, plea of guilty, and the charge?
Yes, sir.
And on page 3, about a quarter of the way down on the page, there's a sentence that reads, "I enter this plea voluntarily," and immediately below that appears to be the signature of Joey Eisen. I'm going to hold that up to the camera as well and ask if that is your signature under that statement, "I enter this plea voluntarily."
Yes, sir.
All right. When did you sign this agreement, Mr. Eisen?
I believe it was maybe last week. Yeah.
Okay. And when you signed it, was your attorney there with you to go over it with you?
Yes, she was.
All right.
Yes.
Did he answer any of your questions and explain everything to you?
Yes.
All right. And did you enter into this agreement voluntarily?
Yes, sir.
You don't feel that you were rushed or pressured in any way?
No, sir.
All right. Now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge in the indictment of aggravated possession of methamphetamine under section 2925.11 of the Ohio Revised Code, a 3rd-degree felony. Further states that you understand that the maximum prison term for that could be 36 months, the minimum could be 9 months, and there are certain levels in between. There's a fine of $10,000 and possible license suspension of 6 months to 5 years. Prison term is presumed to be necessary, but is not mandatory. You understand that?
Yes, sir.
Now, I believe you are facing a charge in Adams County as well, is that correct?
Yes.
And what is that charge?
That's aggravated possession. And
All right, and,
I went yesterday for court on that, and they
Okay.
sent me to a program.
all right, well, in the event that you should be convicted in this case and that case, and if you should ever be sentenced to prison in both cases, those sentences could be ordered to be served consecutively or one after the other. Do you understand that?
Yes.
Are you currently on probation, community control, parole, or post-release control for a felony in any jurisdiction?
No. No, sir.
Now, under the law, Mr. Eisen, if you're convicted of this offense and sentenced to prison, upon completion of that prison term, the law provides that as part of the sentence, the Adult Parole Authority has the right, if they choose to exercise it, to put you under what's called post-release control supervision for a period of up to 2 years under the terms that they set. And if they determine during that period of time that you have failed to comply, they could return you to prison even though you served the entire term set by the court for a period of up to 9 months for a single violation, but there is a cap or limit of half of whatever term was imposed by the court for all violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively, the sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can't impose what's called non-prison or community control sanctions, meaning that instead of going to prison, you would be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the court determined, the probation department determined that you had not complied with those conditions, then the court could at that time revoke your community control and then sentence you to prison for up to 36 months and fine you $10,000. Do you understand that?
Yes, sir.
Now, the charge alleges that on or about October 22, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in an amount equal to or exceeding the bulk amount, but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge with the penalties I just described.
Yes.
Now, do you understand the nature of the charge, the evidence in the case, possible legal issues in the case, and possible offenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with the advice and competence he's provided?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there is a couple of sentences that are printed in bold and underlined that read as follows. Defendant shall enter plea of guilty to the indictment. State defense joint recommend community control referral drug court. Is that your understanding of the plea agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not to the parties. And so even though there's an agreement as to what the sentence ought to be, once I've heard all the information submitted, if I decide that's not the correct sentence, I could sentence you to a prison term of as much as 36 months and fine you $10,000. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No, sir.
Now, you have certain rights you must understand before I can accept a plea from you today. First of all, you have a right to have an attorney, and Mr. Kirk was appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide you do not want to plead guilty here today, that you want to defend against this charge, he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
Under the Constitution, Mr. Eisen, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County, summons for jury duty on your trial date. After they are selected, the evidence would be presented, they'd be instructed on the law by the judge, and then they would decide whether or not the state proves your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means give up the right to have a jury trial, and then in that case you can have what's called a court or bench trial, which means that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do You understand that?
Yes, sir.
Right, under the Constitution, you have a right to confront the witnesses against you in open court, to cross-examine them through your attorney. That means that the witnesses against you have to come into court, testify in front of you and your attorney and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, court issues a court order called a subpoena. That forces those people to come to court and be available to testify if you want them to, even though they don't want to be involved, which is the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to talk about it, except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right. Now, originally, under the law, you are presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. What that means is that the burden of proof isn't on you to try to prove that you're not guilty. The burden of proof is on the state to prove that you are. Under the law, you don't even have to put on any evidence. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you pled not guilty. Not guilty plea denies allegations in the indictment, denies you committed a crime, and it exercises or revokes all the rights I've just described for you. Now, if you change your plea from not guilty to guilty, that's the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime, and that plea waives, gives up all of the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you in open court, cross-examine through your attorney, waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. The waives, gives up your privilege against self-incrimination because you're the one who says you're guilty, that's what used to find you guilty. The waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. And it subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if you're sentenced to the maximum sentence or under other limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that? And are you a U.S. citizen, Mr. Ison?
Yes, sir.
Now, do you have any questions about the charge and the possible penalty?
No, sir.
Do you understand it?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes.
You have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
No, sir.
You understand that?
I understand that, yes.
Do you need to speak to your attorney about anything before we go any further? If you do, I can put you into a breakout room.
No, sir.
All right, you have any questions about anything that I've explained?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the plea agreement that we've just gone over?
Yes, sir.
And you do that voluntarily?
Yes, sir.
All right, then as to the charge that alleges in the indictment that on or about October 22, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code. The charge of aggravated possession of methamphetamine, a third-degree felony, carrying a possible prison term between 9 and 36 months, and a fine of $10,000. How do you plead?
Guilty.
Also carries possible license suspension as well.
Okay.
All right, the court finds on this day in open court, defendant was advised of all of his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal 11. Pleas accepted and ordered filed. The court finds the defendant guilty of the charge in count 1 as set forth in the indictment. The court will order a pre-sentence report and refer this matter to the drug court docket. The report will include an assessment for substance use and or mental health issues. Sentencing hearing will be set for September the 27th at 9:00 a.m. Bond will be continued under the same conditions. All right. Anything further from council?
No, Your Honor.
All right. Then you're remanded back to custody. They'll be taking you back to Adams County. The probation department will be getting in touch with you. Thank you.
Yes, thank you, sir.
All right. All right. Are you Matthew Jackson appearing there on the screen as marked Ghost? Is that, yeah, Ghost?
It should have been Jackson. I thought I changed it.
No, that's all right. It says Ghost. All right. But you are Matthew Scott Jackson?
Yes, Your Honor.
All right. This is case number 23CR107, State of Ohio versus Matthew Scott Jackson. This is a pretrial being conducted by Zoom. Mr. Jackson's attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. And Ms. Witt, you and your client both agree that this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Mr. Jackson?
Yes, Your Honor.
All right. Mr. Jackson is charged with aggravated possession of a fentanyl-related compound, fifth-degree felony. And this is a first pretrial, I believe, final pretrial, a trial set for August the 31st. Now, I've been presented with a plea of guilty form, Mr. Jackson, and I'm going to hold the first page up, which shows your name, case number, and plea of guilty, and says you're going to plead guilty to this charge. And I'll hold that up to the screen there, or the microphone. Can you, I'm sorry, the camera. Can you see that and read that?
Yes.
And is that, you recognize that?
Yes, Your Honor.
You recognize that document?
Yes, Your Honor.
All right, on page 3, there's a line about a quarter way down the page that reads, I enter this plea voluntarily. Immediately below that appears a signature of defendant, and I'm going to hold that up to the camera. Is that your signature on that line under the sentence, I enter this plea voluntarily?
Yes, Your Honor.
All right. Now, when did you sign this, Mr. Jackson?
It was last Tuesday.
All right. And did you sign it at your attorney's office?
Yes, I did.
All right. And before you signed it, did she go over it with you and answer all of your questions and explain everything to you?
Yes, she did.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And do you feel you had enough time to fully consider this matter before you make this decision?
Yes, Your Honor.
And did you enter into this agreement voluntarily?
Yes, Your Honor.
Now, the agreement states that you're going to plead guilty to the charge of aggravated possession of a fentanyl-related compound, a violation of Section 2925.11 of the Revised Code, a fifth-degree felony. Further states you understand the maximum penalty for that could be between 6 and 12 months in prison, a fine of $2,500, and a license suspension of 6 months to 5 years. You understand that?
Yes, Your Honor.
And are you currently facing any felony charges anywhere else?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Under the law, Mr. Jackson, if you're convicted of this offense and sentenced to prison, upon completing that prison term, it is possible the adult parole authority will put you under what's called post-release control for a period of up to 2 years under the terms that they set. If they do, you'll be supervised by a parole officer, and if they determine that you did not comply with any of those conditions, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you're convicted of a new felony, then in addition to whatever sentence the judge in a new case can impose upon you, that judge could also sentence you for committing that violation while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater, which would have to be served consecutively to the sentence imposed in the new case. Do you understand that?
Yes, Your Honor.
All right, now, Mr. Jackson, the court's not required to sentence you to prison for this offense. I can't put you under what's called community control or probation. which means that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. If during that period of time, probation felt that you were non-compliant, they would file a written notice of that with the court. There would be a hearing. And if the outcome of that hearing was you failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for 6 to 12 months and fine you $2,500. You understand that?
Yes, Your Honor.
Right now, the charge alleges that on or about February 18, 2023 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, a fentanyl-related compound, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge that is set forth in the indictment with the penalties I just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
And you understand the possible penalties?
Yes, Your Honor.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are some lines that are printed and underlined, and they read as follows. Defendant, a part of them have been stricken out to show they don't apply, so I'll read the part that's not been stricken out. Defendant will enter a plea of guilty to the indictment. State defense jointly recommend community control and referral to the drug court. Is that your understanding of the agreement?
Yes, Your Honor.
Anyone promise you anything
Yes,
other than
Your Honor.
No. Anyone promise you anything other than that to get you to plead guilty?
No, Your Honor.
Now, under the law, Mr. Jackson, the matter of sentence isn't up to the parties, it's up to the judge, and so even though there's a recommendation as to what the sentence should be, if you plead guilty, once I've heard all the information, if I decide that's not the correct sentence, I could sentence you to prison for a term between 6 and 12 months, fine you $2,500, and suspend your license for 6 months to 5 years. You understand that?
Yes, Your Honor.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, Your Honor.
You have certain constitutional rights. You must understand, Mr. Jackson, before I can accept the plea. First, you have a right to have an attorney, and a court-appointed Ms. Witt represents you. That wasn't simply to work the case out, but provide any defense that could be available to you under the law that you would like her to provide. So if you decide you do not want to plead guilty, she'll continue to defend you and represent you until the trial, if that's what you want, and including the trial, if that's what you want. You understand that?
Yes, Your Honor.
All right, now you have the right to have a jury trial in this matter, Mr. Jackson, in which 12 people will be selected from a group of citizens that live in Highland County that were summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. You understand that?
Yes, Your Honor.
All right, now, under the law, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you and your attorney, and anyone else may be present. After the prosecutor's done asking questions, then your attorney could ask questions. That's called cross-examination, and that would be for the purpose of trying to bring out evidence that would help your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court will issue a court order called a subpoena, and that forces those people to come into court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. You understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. If your decision is you're not testifying, The fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Under the law, you're presumed innocent until proven guilty by the state on every essential element of the offense charged. So, the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now originally you entered a plea of not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits that they constitute a crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. Waives, gives up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives, gives up your right to file an appeal on any alleged violations of your rights you feel may have occurred up till this point in the case. If you should be sentenced to the maximum sentence or under other certain circumstances, you could file an appeal. That'd have to be filed within 30 days of your sentencing entry being filed. And finally, it does subject you to being sentenced immediately by the court. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge and the possible penalties?
No, Your Honor.
Do you understand them?
Yes, sir.
Have any questions about the plea of guilty? About the plea agreement?
No, Your Honor.
You understand it?
Yes, sir.
All right, and again, you understand the recommendation of sentence is not binding on the court.
Right.
You have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand it?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand?
Yes, sir.
All right. Then is it your decision to withdraw your not guilty plea and plead guilty to the charge as set forth in the indictment pursuant to the terms of this plea agreement?
Yes, Your Honor.
Then as to the charge which alleges on or about February 18, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit a fentanyl-related compound, violation of Section 2925.11 of the Ohio Revised Code, a charge of aggravated possession of a fentanyl-related compound, a fifth-degree felony carrying a possible prison term between 6 and 12 months, and a fine of $2,500 and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. Please accept and order filed. The defendant is found guilty of the charge and set forth in the indictment. The court orders a pre-sentence report, which shall include an assessment for substance use and/or mental health treatment. Case is referred to the drug court docket, and the matter is set for sentencing at 9:30 a.m. on September 27th. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. You'll need to contact Mr. Arzima so that you can get your pre-sentence report interview set up. All right?
Yes, sir.
All right. Thank you. That completes the docket, I believe. All right. Thank you, everyone.